our ZBA ZBA meeting tonight. We have two items before us. One is to consider the administrative appeal by Adam and Sharon Smith regarding the proposed adult use cannabis store, and that we will allow, I should say, public inputs allowed. And the other is an appeal by also Adam and Sharon Smith and Stanley Clark regarding repeal of the conditional use permit on the growth facility. That we will be just looking at for completeness and making sure we have all the necessary records. No public inputs allowed at that time, because it's not a public hearing for that. That will be scheduled within 35 days after this hearing. With that, do I hear a motion to call the meeting order?
Motion.
Seconded?
Yes.
Seconded, okay. Yep. So the meeting is now open. One of the things, I'm going to have to recuse myself because I'm going to butter to both of Mr. Ganowski's projects. So based on that, of the 5 members, we still have 4. So we do still have a quorum, so the meeting can continue. And also the question we always ask is there any conflicts of interest? I do have one, which is why I'm recusing myself, because I am in a butter. Gentlemen, do you do any business with Mr. Ganowski? Do you have any issues? Not in the building, that help with the build or anything like that? So
I do not.
You do not? Okay.
I do not.
So it doesn't appear there's any conflict of interest. With that, I will recuse myself. Oh, sorry. I also made I would nominate John McGowan to chair this session since I can't. So I was just looking for a nomination to have him chair the meeting and someone to second it.
I'll nominate John to chair.
Second. Okay, very good. Thank you, and unfortunately, I'll be recused from this one, but I'll be sitting over here, oh, by the way, sorry, we have 3 new members. If you guys just want to tell everybody your name real quick, starting with that end.
My name is Jeff Farrell, live on Benson Road.
William Armington, live on Middle Road.
John Gowan on Molten Hill.
Mike Rova, Molten Hill.
John he's a veteran. He's got over a year. That makes you a veteran in this one. And this is Cameron Farrar, our town attorney. So with that, I will recuse myself and turn this over to the very capable hands of these people.
All right. So we'll start. This is the public hearing for the ZBA for the appeal filed by Sharon Smith. Is the microphone set? How about that? Can you hear me now? Is it not?
I'm not sure it is on. I'm not seeing it. I didn't hear it.
You guys having a hard time hearing?
Yeah.
Hang on.
Likewise, while this is being taken care of, if you address the ZBA, please come up to the microphone so it can all be heard.
Alexis, please keep.
Pardon our technical issues, being addressed by the best people we have right here.
There we go. All right, everyone, hear me okay? All right. So this is the public hearing for Parsons Field ZBA on the appeal filed by Adam and Sharon Smith, March 19th, and the planning board's decision of February 18th, which approved conditional use permit for the adult use cannabis store at 0 North Road, map 09 lot 007. Before we hear arguments, I want to be clear about what the board can and cannot do tonight. Article 6, Section 2A of the Land Use Development Ordinance. This is contrary to a specific provision of the ordinance or contrary to the facts presented to the planning board. We may consider only the record that was before the planning board. We cannot accept new evidence tonight, though we will hear oral and written arguments. We also have the authority under that provision to remand the matter to the planning board for additional fact-finding if the record is inadequate. The burden of proof rests with the appellates. We will hear from the opponents first, and then the applicant, and then open for public comment. Got some notes. Okay, so yeah, one procedural matter first. The appeal was found complete on May 12th, and the call for hearing is in 35 days. The board will not be informed in June, and the hearing is continued to tonight. I ask each party to confirm for the record, do you consent to the hearing being held tonight, July 22nd, 2026, and agree that the 35-day period under Section 3 is extended accordingly?
Yes.
You object? Okay, noted.
I have a friend who mistake.
I think we can make that point. We're going to continue.
Was it the one that was previously submitted, the email? Yeah. Okay. Well, is it specific to the holding of the hearing, or is it relating to
Written statement,
argument?
objection, request for deferral, there's no argument for the towards the actual on the minutes after the vote.
You pass it on now if you want.
These discussions have to be like, we can't hear anything. We can do a public hearing.
Potentially after.
And this guy, they can just pass that mic to anything public.
Should we read this now? Take a look at it? Okay.
I have a brief statement, whatever you want to do.
What do you think? Read it first or brief statement first?
We'll read it first, and then
Okay.
we'll off on the brief statement.
All right, so we're going to take a look at the written statement that was provided, just so the public's aware. all set, Regan? I'm gonna look at you and, get some point in your direction.
Sure, so what's been submitted is essentially an objection from the appellants and a reservation of rights due to the delay of holding the public hearing beyond 35 days. That's required in the town ordinance. The Smiths have noted that they do not consent to the extension of the timeline for holding the public hearing and would object and reserve the right to contest any determination reached by the Board of Appeals tonight as to the application that's currently on appeal, among other things. At this point, my recommendation to the board would be to note the objection for the record, put the objection itself into the board's record, but proceed with the hearing nevertheless. The reason being the board's delay was not due to any administrative error or choice by the town, or lacked adequate number of members to hold a meeting with the quorum, and has reconstituted the board and is holding this hearing here tonight as soon as it is reasonably able to do so. Additionally, as the chair noted, the board is meeting in an appellate capacity. So what that means is that it's reviewing the planning board's determination, but were this to proceed before the Superior Court in a subsequent appeal, the board's determination would essentially be overlooked, and the Superior Court would actually review the planning board's decision in an appellate capacity itself. So the board's determination tonight would not have any binding effect on any subsequent appeal to the Superior Court by the Smiths, so I don't believe it would negatively impact their rights for the board to proceed notwithstanding the objection.
Is this something we would vote on or just agree?
I think you can see if there's any opposition to proceeding given the objection, but my recommendation to the board is to dispense with this issue tonight.
Okay, I agree with council. All right, we will continue to move forward. So I think the first thing that we'll come to is standing. Does that sound right?
Jurisdiction and timeliness and standing.
Can you please speak up?
Yeah.
We can't, we don't want
It's like our mom lady over there, what are you saying? There's several people on this stuff.
I'm happy to try to speak up. I don't have a microphone. There are seats up front. So the order,
There's a bunch of seats up here too. If you guys are having trouble, we'll try and accommodate them.
my recommendation to the board is to, so it becomes harder to hear if there's speaking, but my recommendation to the board is to first determine whether it has jurisdiction over the appeal, then to determine whether the appeal is timely filed, and then to discuss the appellant's standing, which has been raised as an issue in this appeal.
Sorry, guys. You want to just pass it back and forth if you need to? Okay.
But could you repeat that now? Do you have a microphone, please?
Sure. So, at the outset of any Board of Appeals hearing, generally there are several preliminary matters that are discussed. They have a jurisdiction, as in whether the appellant has, or whether the board has jurisdiction under the town's ordinances to hear the appeal. The timeliness of the appeal, whether the appeal was filed within the 30 days required under the town's ordinances, and also the standing of the appellants, which means do they have the legal right to actually bring the appeal under the town's ordinances. So the board will be addressing those issues first.
How should we move through jurisdiction? Is it just stating that this is part of the ordinances that fall under the appeal board?
I think that would be sufficient.
Yeah, since this falls under the Parsonsfield Land and Use and Development Ordinance, that's good. fact that you have jurisdiction to hear this? Does anyone disagree? Is that something we need to vote on, or that's good enough? Okay, great. And then, what was that for jurisdiction? Apologize.
Timelines.
Timeliness? So that would be, was the appeal filed within the appropriate amount of time from the decision? Date received was 3/19. The appeal decision, or the, not the appeal, the decision by the planning board was February 18th. And what's the time?
Could you repeat that again? That sounds you were backwards. You said
The planning board's decision was February 18th,
Okay.
2026.
And what happened on May?
On March 19th is when we received the appeal.
Under the town ordinances, they have 30 days in which to appeal. That appears to be 28 or 29 days.
Okay, so I find that it's in timeliness. Anyone disagree? Great. And then we'll move on to standing. There's some notes on what standing is. So the way it's applied in the ordinance is that there's a three-prong portion to standing. The first prong is where you are directly affected. There's no distance requirement. A property at any distance away qualifies if the person's land directly affected by the permitted use. Water reaching it, for example. Distance cuts either way, neither far away, it doesn't defeat. It does require a specific and particularized effect on the appellant's own land, not general concerns. The second prong is it abuts or is directly across the road, street, or stream. Adjacency, it's not distance either. There's no measurement. For example, a parcel 20 feet away that neither touches the subject property or faces it across the road fails this prong. The third prong is within 500 feet. This is the only one that has a distance number attached to it. So at this point, how do we establish standing?
So, within the opposition to the appeal, 4047 has raised questions as to the appellant's standing. So I think it would be appropriate for the board to hear from both parties as to the objection to standing, and then also from the appellants as to the basis for standing. There have also been written submissions respecting the standing argument, but generally I agree with the chair's statement of what is required for standing. In this case, I don't want to speak for the parties, but from the appellant's submission, they state that they're within 750 feet of the property, the subject property. So I don't think the 500-foot measurement would apply. They don't directly apply to the property, so that wouldn't apply. So really the question before the board is whether the appellant's property is directly affected by the proposed development. And so in that case, basically what you are looking for is a direct and adverse impact on the property. And I can get into it more after the arguments, but I think at this point it would be appropriate for the board to hear from the 4047 and then from the appellant as to the issue of standing, and then to deliberate itself based on what appears from now in terms of argument.
Does that make sense? Everyone agree with that? Okay, we'll start. There's one right there where you can use this one. Yes, we did. Thank you.
This is for all.
There we go, is it working? Yeah. Okay, so, yes, so we contend that the opponents do not have standing. As Cam just said, the ordinance has 3 prongs to it. We agree, and I agree with what Cam has said. The appellants are not within the 500 feet. They are not abutters, and so the question becomes, are they directly affected? Many courts have issued a lot of opinions on what is standing. And there basically is a 2-pronged approach looking at if it's standing, if the appellant does not standing. The first is that the aggrieved parties must show they were a party before the board whose decision they're appealing. And in this case, the Smiths submitted written comments for the planning board hearing, so they meet that requirement. They can come before the board with the written comments. Aggrieved parties also have to show what the courts call a particularized injury. So it can't be just, oh, we don't like this. We don't like this in our neighborhood. Oh, everybody in our neighborhood is going to suffer because of this. That's not what it is. They have to have a particular injury to their land. So it has to be a direct cause of harm to their specific property, money, or personal rights. So they also can't say things like, well, we think if a cannabis store goes in, we think it's going to lower our property value. That's speculative to begin with, and it hasn't happened. The property value has not been affected by the planning board approving the conditional use permit. The harm cannot be something that is shared identically by everyone in the area. So there's been a lot of talk about water runoff, but everybody in the area has been talking about water runoff. It's not specific to them. And they have to show an actual specific harm caused by the board's decision, not that they live nearby and don't like that one. Any questions?
Could you submit it for yourself to the?
Oh, I'm sorry, I'm Tammy Snow. I'm 04047's counsel.
I don't have any questions. Does anyone have any questions at this time? Thank you.
I don't have anything to say, as I stated before, I object to this hearing, and I'm not participating in the So with respect to the question of particularized injury or particularized harm that Attorney Snow raised, respectfully, I disagree. There's a lot more precedent out there that states that, normally for judicial standing, you need to show particularized injury, which would be some adverse impact to your property, your personal or pecuniary interests. But the law court has held that municipalities, in the context of administrative appeals, such as appeals of this board, are free to modify that standard. So here, the town has chosen to provide standing properties that are directly affected by the proposed development without any reference or requirement for a specifically particularized injury or particularized harm. So in that context, what the board is really looking to establish and determine is whether the property is directly affected in some manner by the proposed development. And the relevant case law that I'm pointing to is Upstream Watch versus the City of Belfast, which is a decision from 2023. But in that, basically, the law court held that the appellant there had demonstrated a particular direct impact to their property by showing that there was potential impact to the project by drawing large amounts of water from a local aquifer property near enough to the property wall, excuse me. Yeah, it would be owning, yeah, so it says, at least one member was an aggrieved person due to owning land that will be directly affected by the project, such as the potential impact that the project's drawing large amounts of water from a local aquifer could have on their well. So that's where the impact would be sufficient, even though it doesn't necessarily rise to the level of particularized harm, or particularized injury. So really, if the board believes that there's evidence in front of it sufficient to establish that the Smiths will have some type of direct impact to their property, then I believe that would be a basis for the board to establish their fine standing in this case.
Can I respond?
Sure.
I have a copy of the case here.
Oh, great, yeah, thank you. Yeah, so again, we're looking at, do they have specific harm? And they have not, in their written comments, which is what is in the record, they claim no specific harm. Everything is general that they claim. So I have a list here of all of the things that they were claiming. Somewhere. Oh, I'm sorry. I have too many papers. They had a list of things that they were claiming to the planning board, and they were that the conditions associated, they said that the application was incomplete. And the conditions associated with the country store, which is not what we're doing here, were not included in the application. No interior layout of the building was one of their objections to the planning board. Application fee was not collected. Sidewalk was waived. No traffic calculation. No mention of how watering would be dealt with. No explanation of how two entities, this country store along with the cannabis store, could be at one location. They did mention drainage issues associated with the section of the road at the proposed site, which has nothing to do with their property. It's drainage at the proposed site, and a well and septic plan were not submitted. So none of those things had anything to do with their property.
I have a question with, isn't there a water survey that the state does? Is there some type of a water survey that happens?
So there could be, but we can only consider what was in front of the planning board.
So they never required that, the planning board never required that?
It's not up for us to decide what to get in, not required, it's just.
So, with respect to standing, the board isn't necessarily limited to the record before the planning board. You can consider the submissions and the oral testimony of the appellant and the CO 4047 here tonight, because it's a question of the board's, jurisdiction and ability to hear this appeal, as opposed to the merits of the actual appeal itself. So, I think the most appropriate information for the board to consider would probably be the appellant's May 4th, 2026 submission. You guys have a copy of that.
I don't think you do.
Yeah. Well, I have a copy here that I can pass around to the board, or I can read it if you want me to read it, whatever you prefer. Like, essentially what it says is that it's submitted by the Smiths dated May 4th, 2026, and there's an addendum relating to standing as an aggrieved party. And essentially what it says is that their property is located within approximately 750 feet of the proposed site, and the direct and particularized impacts to my property interests arising from the decision. They claim that the approved project alters the existing stormwater drainage patterns in the area, that the record contains testimony and photographic evidence indicating stormwater associated with the project that's already impacted properties located between the site and my properties. and that the record further includes public testimony and evidence from nearby property owners documenting similar off-site stormwater impacts and confirming that these drainage issues are occurring in the immediate area. Then they further state that several property owners further testified that based on decades of experience living in the area, no comparable flooding or drainage issues have been observed prior to the development of the project site, and that such conditions have only arisen following site disturbance, and these properties are part of a continuous drainage path that conveys runoff in the direction of Mine Lane. And then in addition, that the proposed use introduces commercial activity and associated site features, including lighting, signage, and operational impacts that are incompatible with the residential and historical character of the surrounding area, and that these changes adversely affect the use, enjoyment, and character of the Smith's property in a manner that's not shared by the general public, and are reasonably expected to result in decreases to their property values. That, in sum, is the basis for their claim to standing. So I think the question for the board again is whether the board would regard that as demonstrating a sufficiently direct effect from the proposed development on the Smith's property. I can pass this around if you want to read it.
Yeah, let's take a look at that.
You have a copy of that?
I don't have a copy of it.
Do you,
I haven't got
sorry,
it.
not public comment at the
Yes.
moment. Not yet, yeah. Thank you for reading.
I want to see it.
I got the. I know. We only have one copy, so I'm letting the board do it. Just with that.
Yeah.
So, both of these,
We've had full copies. This is the manual. I will give it to you. No, I know. I was suggesting you worked out any copies. No.
I told them up there to be
Here, forward you that, you know. We'll have this whole thing, it's just not gonna have my notes.
Okay. How many copies do you need?
One for the board members and one for Tammy.
So in case anyone didn't understand, we're waiting for copies to be printed, being provided to the attorney, provided to the board, and we'll read through that, continue standing discussion.
You can note for the record that Attorney Snow, you can note for the record that Attorney Snow has objected to the board's consideration of the letter, that we should receive a copy prior to the date of the meeting.
Noted.
And Chris respond to the argument.
Can we just let the board get copies first?
Oh,
and
I'm
then-
sorry.
Sorry.
I'm sorry.
Okay, Louis. Yeah, okay.
sort through, or do you guys want to just go through them and pass them around?
So it's really just that final page.
All right, so the board has completed reading the letter. I have a question to Cam. Cam, with reading through this, is there any burden of proof that needs to be presented tonight by either party for their claims of standing?
The appellant would generally have the standard or the burden of proof demonstrating standing, so it's up to them to prove there is some direct effect from the proposed development onto their property. That would lead the board to determine standing.
And what does proof look like? Is it just like them saying something, or do they have to have pictures, or like where is the line of proof?
So ultimately here, it's a fact determination for the board, so it's sort of a discretionary determination on your part as to whether you think there's been enough information provided to you to, determine reasonably that there is some direct effect on their property.
So I guess we'll start discussing the standing.
I think the applicant wanted an opportunity to respond to my prior statement.
Oh, yeah.
Yes, good afternoon, I just wanted to respond to the comment agreed by the stormwater runoff. As my attorney previously stated, they have had many arguments of how they were affected, all of which have been dispelled at this point. We did not alter any stormwater runoff. That has been accounted for by the town code enforcement, named DEP, named DOT. The flooding that occurred in 2023. We did not do any alterations to the land until fall of 2025. My properties were also affected by the flooding that occurred in 2022, and I believe that all of that considered, leads to that they do not have standing. Yeah, and I did walk the properties with, all of my properties with code enforcement, showed them where the water comes on the properties, where the water goes off of the properties, and that was all good whatsoever. Thank you.
Anybody got any questions tonight? Would it be appropriate to start deliberating standing at this point? Who would like to go first? I gotta hand it to Mike.
I would just like to mention my objection one more time.
Noted.
So I guess with the whole water thing, I don't know how we can do this where the planning board never looked into this. It was just, one says it's good, one says it's not. And we're still trying to deliberate that, whether that happened or not. I feel that they possibly could have standing, but if we don't have any surveys or anything with stormwater drainage, and it was just a code enforcement guy maybe saying something, I don't know how we could say true or not, but I feel when they are close by, they have to have standing. I don't know why they wouldn't.
So the one thing too is that they specifically have to describe how they're impacted. And I think we can talk through that a little bit with the letter that they provided. So some of the things that I see through the letter is that they talked about several property owners testified, and that they had issues, drainage issues because of that, but they didn't specifically state that their property did. They said that the continuous drainage path that conveys runoff in the direction of the land, but they didn't specifically say that it's impacting their land negatively. The other thing that I saw was that it creates a direct and non-speculative risk, similar impacts to my property. That's talking about what could be, that's not specifically outlining how this property is impacted or how they're impacted. And reading through the rest of the letter, I don't see anything that specifically says my land, my ditches, my property was impacted or degraded in any particular way. And I think that's the level that we're looking for, whether it be in a letter or a statement or some kind of direct, this is how it impacted me. Does that sound right, Kim? Do you have anything that you want to add or correct?
I would just note that since the development hasn't occurred, all of the statements of direct effect and impact are necessarily going to be somewhat speculative, since the groundwork and the building and everything haven't yet been constructed here. So, sorry.
The groundwork was started.
The ground started since the
Yeah, it
building
started,
hasn't been constructed.
and that was considered at the planning board meeting, this whole stormwater thing was
Yeah.
considered there.
So sorry, the groundwork has been undertaken, but the project hasn't been fully constructed yet. So there is going to be some speculation as to the impact.
But they're saying that the impact is now.
So the fact that it's a potential impact isn't necessarily definitive, but generally you're correct. Yeah.
Anyone else have anything to say at the moment? I think at this point we can give it back to the opportunity for either party to make a statement. No?
They had their chance, and now it's the board's chance to deliberate and determine whether they think there's a demonstration of a direct effect on the property sufficient to give the appellant standing.
I can say something.
Yeah, we haven't closed the deliberation yet, so we continue to talk.
So going back to this whole water thing, it's still hard for us to decide whether, I mean, he's gonna have, this, I mean, we don't have true evidence on that, and this is all part of the standing, because it says, the big thing here is about drainage, and it wasn't a stormwater survey done. How do we know whether even though it's within, they're out of the 500 feet, water travels, and it could still go down and affect this, especially when more parking lots and more drainage is done. Was that ever discussed at any of the planning board meetings and sketches and all that? And was this survey done to know, is this water thing gonna be potentially a problem in the future to go across that ditch that's along the edge of the field that can go into someone else's land and keep going? So I just feel that there's gonna be some type of standing if we don't have any evidence to go about it.
I think Pat started to maybe look at the merits. Would you agree with that, Cam? As opposed to specific to standing?
I think what's being gotten at is essentially whether there's actually evidence in front of the board here tonight, and the board can point to and say, yes, this is proof of a direct effect on the property, beyond the appellant's own statements. So I think it's appropriate, given that it's the appellant's burden to establish standing, that the board consider the sufficiency of whatever information and evidence is in front of it. I don't think it's necessarily improper to consider record evidence in the context of a standing determination. That makes sense.
As far as evidence goes, a question for the town ordinance says that we have to prepare for ditching is supposed to be set by 25-year flood level, main event over a 24-hour period. And it was mentioned that there was a flooding back in 2023, but was that a 25-year, 6-inch historical event, or was that more, was that less? I mean, I think that just because that there wasn't necessarily evidence of flooding doesn't mean that it could have gone to that level of flooding. I mean, it's a historical, I mean, if that makes any sense.
And I also feel like for the standing for us as a board, they were already getting back into something that was the planning board's deal. And if we don't have the correct evidence, if they miss some steps, I don't know how we could go further and have all these questions asked if that was not our job. Not saying I'm for or against this at all, I'm just trying to be a fair man and go by what's going, what's been said, and if there was steps missed, then this is a hard place for us to sit here if things were missed in other meetings.
Can I ask if the zoning board has reviewed the planning board meeting to see what was?
This is a public hearing, everybody needs to hear what you're saying.
Has the board had the opportunity or gone back and reviewed the planning board hearing to know what was actually discussed? This was discussed a lot. Have you watched that planning board hearing and where that was discussed? Yes?
Yes, we've had the opportunity. Are we allowed to ask questions about standing? I was reading the question, right? So I guess my question would be, with this fence, is when they said the continuous drainage patch that conveys runoff in the direction of my land, are there additional details with that?
It's not saying the application is already being complete, the town will meet its own deadline, regardless of fault from the matters now before the Superior Court.
Also, for the standing, how many points does one need to have standing?
I think it's, let me know if you can't hear me in the back. I think it's mostly just the folks that have filed the appeal need to describe how it impacted them directly. So if we look at the three prongs, right? The first prong is directly affected, which does not have a distance. And it's any property that's a distance, any distance away can qualify if they're directly affected by the permitted use. And I think what we're looking for is the description of how they are impacted, because I don't see anything in the letter, I don't see anything that specifically says how they're impacted. I see how their neighbors are impacted. I say where, between two different areas is impacted, but I don't see anything that specifically says where they are impacted.
So you're saying their verbiage was a little off in place?
I'm saying that we have to consider what's in front of us and what we've heard and what we've read. Would you guys like a couple more minutes to just collect our thoughts? Or if we have if anyone else would like to ask a question of either party? Last call. For closing deliberations. All right, at this point, we motion to, we make a motion of what somebody thinks the standing is, and then we second that, and then we vote on that.
Basically, I think in making the motion, you should
Yes, generally now the board's free to, make a motion as to whether standing is or is not, has or has not been demonstrated. I would just ask the member making the motion to provide a brief explanation as to why they feel the standing has or has not been demonstrated.
They do say that it's on to my property, there's plenty of bodies, you know what I mean, there's things that, these properties are part of a continuous drainage path that conveys runoff in the direction of my land, which means that as a result of them having standing that affects their property, whether they're within the 750 feet or 500 feet or not. So that first clause that's in that ordinance does say that there's a couple other things in here. Drainage patterns are relative to my property, so there's things that they do talk about their property, not just other people's
I
stuff.
understand that. It says in the direction of my property,
Yeah.
not my property.
Would you like to make a motion?
Oh, yeah. I'll make a motion that they have standing.
At this point, do we vote, or is that enough? Okay, raise the hand that thinks that they have standing. We're deadlocked.
No, they're not.
Is your hand up or not?
Motion passes. So next up is the merits, or?
So the board can, it's the board's practice generally to hear from the appellant and then the applicant first, and then open up to public comment. That's my understanding.
Yep.
That would be the way to proceed.
All right, I'd like to hear from the appellant first.
I'd like to request that this statement is noted in the minutes, please. Our appeal was deemed complete on May 12, 2026. Under Article 6, Section 3B of the Town of Parsonsfield Land Use and Development Ordinance, the zoning of the Zoning Board of Appeals was required to hold a public hearing within 35 days by June 16, 2026. The town scheduled a hearing for June 16, canceled it on June 3rd, and then on June 8th, issued a cannabis license that required the underlying conditional use permit to be appealed. We notified the town in writing of the approaching deadline. However, the town allowed the deadline to pass without holding a hearing or providing us with any further communication or a new hearing date. No extension of the deadline was agreed. We filed our Rule 8B appeal on June 15, 2026, and a motion to stay further ZBA proceedings is currently pending before the Superior Court. This hearing today was scheduled only after the town received notice of our Superior Court appeal. The issue is not merely one of timing. The town failed to act within the ordinance's mandatory deadlines, failed to communicate any plan for addressing the appeal after canceling the original hearing, and took no apparent action to reschedule the matter until after the Superior Court appeal was filed. As a result, the ordinance's mandatory hearing deadline was ignored. The hearing now occurs not only after the deadline for conducting a hearing, but also after the ordinance's deadline for issuing a written decision, placing our appeal rights at risk. Because the town did not follow its own required timeline, and a stay request is pending before the Superior Court, we object to this hearing going forward and request that the ZBA take no further action, including issuing a decision, unless and until the court rules on the stay. We are appearing solely to preserve our procedural objections. We do not waive those objections and are not participating on the merits.
Anybody have any questions before we move to the next? All right. Council, would you like to?
From what I understand, the poets do not want to move forward with this appeal. So I don't see any reason in moving forward if they're withdrawing the appeal, if I'm understanding correctly.
I don't think there's been any official request to remove their appeal status.
Well, they just said, they did. What did he just say? That he waited
Said that the
until-
Superior Court, he didn't waive his rights or
Well, okay.
withdraws appeal.
Okay,
Well, it was Superior Court, however, he said this is not a hearing that he is participating in.
The public, so,
Excuse me?
Guys, let's try and get through this so we can get it. Thank you.
Is there any additional statement or argument from the applicant?
I just don't see the point in going forward.
I understand that you might not see the point, but it is moving forward.
Okay.
Would you guys, is this, do you have anything else you'd like to say during this part? Is this where we would ask questions?
So, it seems that the appellant and the applicant are essentially both resting on their written submissions to the board at this point.
Yeah.
Obviously, the appellant has objected to the board proceeding, the board's noted that for the record.
I don't would probably just be best to open it up to public comment at this point, hear that out, and then to the extent the board has questions, you should really just be referring the written submissions since both parties have chosen to rest on those.
Okay, everybody? All right, we'll open this up for public comment. Please, orderly, go ahead and head to the microphone. First one there, go ahead. Please make sure to state your name and whether you're a resident of Martinsville or not.
Kathy Libby, president of Martinsville. So we've been coming to all these meetings, and I don't know where they've been, but we've heard over and over about how the different people's water issues have been. I don't know why they said that there has been a problem, that nobody's heard of this, you know, that there's no big deal. If you look at those monitors, if you can't remember that whole state that you read, you had to go have coffee, and you don't want to wait through that. We all were here for that meeting, so was she should have heard it. It seems like everything we said, the planning board that night, we all stood here. We were tons of us, telling them why we had a problem with this. But yet, off it went, as soon as we all get in our cars, boom, off it went, they passed it. It seemed like in the next meeting, it was the selectmen. And it's the same, same thing. As soon as we get out of their way, everything went through. All the paperwork that got submitted to the moratorium, as soon as it got submitted, they backed the date up, by the way, this went from Plainview. Okay, you got on the chocolate block for that one. And it was your fault because you're the one that supposedly suggested it, okay? But they changed the date that we legally got in on time. A date was changed
We're going to give
legally.
you another 30 seconds now. I'm going to interrupt you.
All right, but the date was legally changed so that they could get that date for him the day before they backed it up to. I mean, it's like they've just been working all around us.
I hear you. Thank you for your participation. Thank you all for coming. I do need to remind everyone that this can only be in regards to what occurred during the planning board meeting. So we can't talk
That is
about
a planning board meeting.
the specific planning board meeting that was approved. We
Yeah,
can't talk
that's
about the
the one
board
I'm
item.
talking about.
We can't talk about any of these other things that happened after. So that's just my reminder. Please.
Marty Ollerson, and my property is directly above the proposed property we're talking about. It's so in light of everything that's been brought up about the water concerns and the water issues, July 16, 2023 is when my property and surrounding properties saw a considerable flooding events. It down 160 right through my yard, and I believe that was a thunderstorm or something related. That the fact that we've had heavy rain events and nothing to that degree had occurred before. So anyway, I'm just mentioning this because I wrote about it to the planning board. I sent pictures. I have pictures. They are in an email. And I have been to every meeting. And I never understood even in the beginning of the planning board why there was one sidewalk, because when we could talk about the water issues that have occurred historically. You know. So I can't speak to specifics with who Chris was met with and all of that, and I know there's been more work done to save trenches and direct water and whatnot, but I feel that there needs to be some bigger oversight with that, with the organizations and the groups that monitor those things related to businesses and towns and roadways and properties and whatnot. And, you know, I'm just a 30-plus year resident of Martinsville who just is a quiet neighbor and very proud, typically. So I'm not bringing this up to vilify anybody or whatever. This is just my reality. This is what I have dealt with historically, and the things that were mentioned, and you know, the buffer, like should my property be the buffer between the clear cut of the property and the business? You know, there should be something, a plan for that, and there isn't. take note of that, written down during the planning board meeting, okay, we never heard another word about it. It's not my responsibility to plant more trees for, whatever reason. So those are just my concerns, and my concerns are really largely with, things that have not happened in terms of the town government, planning board, and so forth. And it's just hard to, that's my piece.
Hi, I'm Walter Shaw, I live here on North Road, and unlike my neighbor, I will vilify both this board and most of our town government in the fact that they,
I'm going to interrupt you and remind you that this has to be in regards to the facts that were stated at the planning board. This is not-
or during this meeting.
Or during this meeting, absolutely.
All right, so during this meeting, you all took roughly an hour of our time trying to decide on something that you should have decided when you reviewed the application. If the application didn't have standing, then we shouldn't be here now. But clearly, then you decided it had application. And now there's a number of new members who, for whatever motivation, want to cloud the issue. Speaking to the planning board, we can look back to the fact there was no sidewalk. There was no issue or no resolution to the issue of the water. There made no provision for the traffic increase on the road and the safety of our citizens. And for those reasons alone, you guys should overturn their decision and send it back to them in the hopes that they will do their jobs. We may not like the way it turns out because the water survey may show that there's no impact. But we don't know that if there's not a survey done. There may not be any traffic impact because, we're out here in the middle of nowhere. But we won't know that unless there's a survey done. These conditions were not put upon this gentleman. And given that there's this pending appeal, the fact that he continues to make progress on his property is reprehensible. You or someone in the town should make him stop until this situation is resolved. Thank you for listening.
So just a quick point of clarification for everyone's education. We cannot determine standing at the review process. So that's why that didn't occur. We'll take as long as it takes to decide standing because we want to be fair to everyone. So I'm sorry it took a while. I want to get on too, but we need to follow the process to respect all of our citizens and community members.
Just with respect to the continuation of construction during a pending appeal, under the town's ordinances and under main law, generally, the filing of an administrative appeal or the filing of a Superior Court appeal don't automatically stay or pause work under a building permit. Any work that is done is at the permittee's own risk. So were the court to come through or were this board to come through and revoke the approval, then they would be at risk of basically losing their investment in the property at that point. So it's not a basis. Filing of an appeal is not a basis for a stop work order unless it's explicitly set forth in the town's ordinances, which it is.
Yeah, we also have the ability to change our local ordinances. So if you don't like the way the process is done, please, there is a process to change that. Thank you again. Next.
Chris Broad, Parsons Field Resident. Some of you heard me speak before. As far as my understanding is, if you clear a large lot like that, you need to leave a buffer, both on both sides and the road. My understanding from reviewing some of the planning board stuff is that he was told, the planning board was told that he was going to use it this way, and then he changed in midstream. And he was told that if he did it this way, he could clear it all, and now it's changed. right in the street. So he got a permit to do this and did that. And I just want you to know, that doesn't flatter the public.
Thank you.
Jack Tennessee, Parsonsville resident. I've got a couple of questions or issues, whatever. The one is 04047's council stated, for standing, that there was no effect on property value. Okay? Well, unless the council has got ESP, this always happens. It's historically happened after commercial buildings or businesses move into a residential area. Property values drop. Not today, not tomorrow, but they do drop. That, as far as I'm concerned, is standing. Okay? My other question or concern is, this has been a problem for months, all right? You know that there's been a lot of opposition to it. Why did we wait until tonight to have the town attorney here? Why has he not been here before? That's all I've got to say.
So the town attorney is here specifically for this meeting. Why this meeting did not occur beforehand is because we didn't have a quorum of the board. We didn't have enough members. So, yeah, we have a lot of new guys, but they seem to be the only ones willing to do the job.
He wasn't here for the select board meeting, he was not invited today. I'm not saying it has to be included, but the horse has already got his barn, and now it's here. That's all I'm saying.
Yep, noted. Thank you. Next.
Yeah, Denise Crooker, I'm a resident of Parsonsfield also. Personally, I have no problem with marijuana being sold in Parsonsfield. Because it is sold in Parsonsfield. But what bothers me is this is deemed a historical area. And it just doesn't seem right. We've got the great big Class M up there, these buildings that are so old. Your house is old. Why are we going to create this busy type of area that is warm now and inviting, and it might not be? And I just object to that. I don't object to marijuana being sold in Parsonsfield. Thank you.
There's a car show coming up to Parson too, if anyone didn't know about it. Great cause and support. Anyone else? See Tom chopping at the bed. Tom, let that cut some in. No? Okay.
I'd advise against it.
So last call before we close public discussion. All right.
Good evening, my name is John Marble, I am a resident of Parsonsfield. I have a question for the board. What I hear is that it's a and please feel free to correct the grammar, conditional permit? What does conditional mean? And the second question I have, did the planning board issue a permit in accordance with the written ordinances of the town? In other words, is this an invalid permit?
So with respect to the terminology, the application is for a conditional use permit. A conditional use permit is essentially a permit that's subject to additional or heightened scrutiny from the planning board and has to satisfy additional criteria beyond what might normally be required under a normal building permit application or site plan review or something like that. So in the land use ordinance article, whatever it is, sets out the 4 sets out the conditional use permit application and approval process. A conditional permit would be a permit that's approved subject to certain conditions. The planning board did not attach any conditions to the permit that's under appeal tonight, so this is just a conditional use permit. With respect to whether the planning board followed all of the processes and did everything that was required to do, that's what the board is here to review and decide on tonight.
Does the board have that knowledge to make that decision?
I think I'll leave that up to the board members to determine, but that's
I'd like to hear your
ultimately,
answer.
yeah.
Can you repeat your question, please, Jim?
My last question was, does the appeals board have the knowledge to know whether the planning board followed the proper procedures and issued a permit, conditional permit, in accordance with both proper procedure and within the ordinances that of the town of Parsonsville?
So my answer was we've had adequate accessibility to the facts, to the planning board, to the resources, to the state resources. So I feel that we're good. Anybody else? You beat you. All right, 1 second. Gentlemen.
My question just was, is that the question that you just asked, Frank, is did the planning board follow the procedure?
So this part is for the public to comment. Once we close the public comment, that's what we will start discussing openly in front of everyone, Mike. And that's what we're going to figure out. So based on the statements, based on documentation, based on planning board meeting, based on public
I
comment.
have a question though, so.
I'm sorry, would you mind going to the mic just to make sure?
Yeah, we can.
Thank you.
So my question is that I was told that a 4,800 square foot building qualifies for a different procedure than a 6,000 square foot building. I don't know, I know we're talking about 2 different buildings he owns, or he's working on one, owns another. But a 6,000 square foot building, I thought was like in a different category. They actually had to have more supervision of what they could do. It becomes a different scale of property building versus a 4,800 square foot building. So when he jumped his numbers up and then got a plan for that, and then got a permit for that, he went beyond that size of what he, the boundaries he originally was supposed to be in. Yeah, so that was one of the things that, like, this has been going on, there's lots of little things, I'm sure, they're statements that they're gonna use in court, explaining that there was a lot of little things that they just didn't follow, and every time he went to do something, he did something else. And the planning board just blind-eyed, even during that meeting, they blind-eyed everything everyone brought up, and just pushed it through anyway. That night, they pushed it through like none of us ever existed, and we had a room full of people. And same the night after that I can't talk about tonight.
So what we're going to deliberate and talk about once we're done with public portion will be, did the planning board exercise their duty correctly? So these things will come up during that discussion.
So do you want examples right now then? Things that they...
I cannot talk about what I want or look for. All I can do is say if there's public comment, you're welcome to give it.
So, Sushi,
Sorry,
questions,
1 second.
some of mine.
1 second.
I was just going to say, I think the distinction here, and I agree that it's not relevant to the appeal that's before the board tonight, other than, the completion, termination that's coming up. But with respect to the 5,000 square foot determination, basically, what you're talking about is the differentiation between the level of site plan review that kind of developer undergo. So if it's under 5,000 square feet, it's classified as a minor development. If it's over 5,000 square feet, and I'm not going to get into facts or anything right now. I just wanted to let you know, in case you were looking for it, the town's ordinances. It's under the site plan review article.
So you guys are going to deliberate over here this evening
Yep.
in front of us, so we'll know who voted in which direction.
Sure will.
Excellent, excellent.
It's all recorded too, and paperwork as well.
That's fine, that's fine. The last meeting with the planning board, I don't believe that we were privy to the actual vote. They did it afterwards. But my only other thing is that I implore you to take into consideration prior bad acts when you consider this, and some oversight.
So, I'm sorry, I have to interrupt you. We can only talk about what was in front of the planning board. We cannot do anything else, other than what's in the applications, appeals, whatnot. I have to tell you that.
And I appreciate that, but that doesn't stop the fact that you heard it. So, thank you very much.
You don't want to repeat that what I repeat. Okay, wait for
Sorry, I'm trying to ask you to go to the mic. Or you could speak up louder so we can hear you at home.
What I mentioned earlier about living buffers has to do with the planning board. The planning board was told he's going to do this, and then they approved it. And then he went and did that. He's just trying to show us consistency of not following what he asked for and doing something else. And that, what I'm mentioning, happened directly to that piece of property right there. No buffers whatsoever.
I'm going to say the same thing. You can only consider what was in the appeal, the planning board decision, and planning board meeting. All right, last call.
Sorry, I'm assuming that we have the code enforcement officer who has actually gone out and followed the checklist and stuff like that, that the work that was permitted was actually done. Is that true?
I would refer you to the CEO and the select board. We are only here to consider what's in front of the planning board.
Okay.
The appeal.
Yep, I'm sorry, yeah.
All right. Last one, anyone? All right, it's time to close public discussion. I believe that means we'll move into deliberation. Does anyone want to start? This is where we can talk about what was in the meeting, if we have any thoughts about the planning board not executing the meeting correctly, and why, and how that applies to our ordinances. And I think there's anything you'd like to add before we start?
No, I mean, the board's free to deliberate. I think the substance of the appellant's arguments is in the 4th 2026 letter that was submitted, in addition to the actual application for appeal. The 24 findings of fact are also included in the appeal application, so I think it would probably be most helpful for the board to review the arguments raised by the appellants in order in which they're presented, and then just deliberate on them and see whether they believe there's any basis for determining the planning board act in violation of the tax levy ordinance, or any additional findings are required for the board to appropriately review the issue before.
We have like a minute to look through things and then have questions, do a little bit of markup. All right, we'll take a little minute to put it all the documentation in. No. And just a question, we can use all the planning board meeting that was discussed, right? Okay.
You're free to review all the information that's put in the planning board meeting minutes, the findings of fact, and the public comments and the
something I do want to direct the board to is part of the packet that has a paperclip. At the end of it is the finding of fact, which would be a good thing to review as well. The question was, do we have to be on the mic to talk about things about themselves, and the answer is yes, we can.
Just wondering if Jeff, I know if our town attorney could tell me or not, with the buffer strip that was supposed to be left around that property for a building like that, and now that it's gone, is that, what's that in our ordinance that says? I know you could probably cut it all at one time if it was for one use, but like they said, if it's changed use, I think there's things that's been missed. So, with all the discussion that everybody's had and all the meetings, me as, even though I'm a new member, I've paid quite a bit of attention to other things that have happened in the town. And I'm not saying that anybody did anything maliciously. A lot of people can miss things, and to be fair for the town residents and 404 and 47, I just feel that things have been missed. I'm not saying I'm making a statement call or anything for voting or anything, but I think things could possibly have been missed.
So with respect to the 25-foot buffer, I mean, this is a conditional use permit application, so really what the board is considering is whether the planning board determinations under the conditional use approval criteria were sufficient. The conditional use permit criteria don't specifically incorporate the 25-foot buffer requirement. That's a separate requirement under the town's other ordinances. So it's not necessarily applicable. The existence or construction of the 25-foot buffer is necessarily applicable in this instance. The way in which it might come in or come into consideration is the question as to whether the proposed use would have adverse impact on surrounding properties greater than another permitted use within the zone, or similar permitted uses elsewhere, just as the way it's oriented or the way it's proposed. And that would certainly be a proper question, but I don't know otherwise of a basis necessarily for bringing in the specific 25-foot buffer into the board's review of the planning board approval at this point. If it's helpful, we can run through the conditional use approval criteria and the reference briefly in the planning board's findings of fact, but are specifically laid out there.
I think that's a great idea. Do you mind doing that for us?
Sure. So generally the way the conditional use permit process works is, someone submits an application, and then there are standards laid out for the granting of a conditional use permit by the planning board. Essentially, there's 3 buckets, 4 buckets if you have a property in the shoreline zone, but I think it's agreed by all parties that this property is not within the shoreline zone under the town's ordinances. So basically, the 3 standards are that neither the proposed use nor the proposed site upon which the use will be located is of such a character that the use will have a significant adverse impact on the value or quiet possession of surrounding properties greater than would normally occur from such a use in the zoning district. And then the second standard is that the municipal or other facilities serving the proposed use, such as water, sewer, things like that, will not be overburdened or hazards created because of the inadequate facilities. And then C, that the natural characteristics of the site, including topography, drainage, and relationship to ground and surface waters and floodplains, shall not be such that the proposed use, when placed on the site, will cause undue harm to the environment or to neighboring properties. So those are in broad scope, broad view, the 3 main criteria that the planning board has to find. In reaching a determination on each of those, the planning board is obligated to consider certain things in the ordinances, or the tax ordinance. But ultimately, the substance of the appeal tonight is really that. Let's pull it up. As it's laid out, that, the appellants allege that the planning board erred by granting approval because none of the 3 standards are met. They're making arguments about the consistency with the purposes of the village residential district, the screening requirements, specifically the 25-foot buffer requirement. However, that requirement's located in Article 2 of the town's ordinances, not within Articles, whatever I said, 4 governing conditional use approvals. Consistency with the comprehensive plan, and those are the general objections. So I think we'd be, happy to talk with the board more or answer questions about the specific approval criteria. I think that would probably be most beneficial to the members of the public attendance into the board's deliberations to kind of try to roll through the arguments that have been raised by the appellant as to the specific standards that are laid out in that May 4th letter.
Can you talk to us about Article 4, Section 3?
Sure. Is there a specific question?
Yeah, I think it relates to the planning board's duty.
So it says a conditional use may be granted by the planning board only in the event that the applicant is established to the satisfaction of the planning board that. And then all 3 of those standards that I previously read out before would have to be met. Is there something more you're looking for?
What about Section C? Can you read that again for me? I'm sorry.
Sure. The natural characteristics, this is a 3rd requirement for the conditional use approval, which is the natural characteristics of the site, including topography, drainage, and relationship to ground and surface waters and floodplains, shall not be such that the proposed use, when placed on the site, will cause undue harm to the environment or the neighboring properties. So essentially, whether the proposed development will result in undue adverse impacts to the environment or to neighboring properties.
Are we allowed to ask questions of the
At this point, I mean, both parties have rested on their written submissions. I think the board should honor that.
I didn't see any engineers through drawings for drainage or verification of that. Did you guys? It seems to align with seems to align with section 3C a lot. If there wasn't, like, if they didn't produce an engineer to prove whose word are we taking it at, that makes me concerned about incentives. Not that there's any malicious, I'm not inferring that there is, but in order to, for the board, for the planning board to ensure that, I would think that they would need some kind of independent body to evaluate that.
That's required, I think it's required by our town. It was required by our town code, and it's written in as well.
So, with respect to the conditional use permit application, what's required is under, in terms of the contents of the application, is under section 2A of Article 4. I think the relevant one is that the applicant must present a scale drawing of the lot, the locations, any existing or proposed building structures, natural features, driveways, and parking areas. And then also in subsection D, they must submit such other materials as will enable the planning board to determine that the standards for approval of conditional use have been met. And those are the two relevant sections. The application requirements themselves do not call for an engineered stamp plans. However, the planning board would have been free to request those had they deemed necessary. So I don't think the lack of an engineered plan would be a basis for the board to determine that the application is insufficient, or the planning board should have rejected it. The question would be whether the plans as presented to the planning board provided a sufficient basis for the board to make the findings that it made.
Gotcha. That makes sense. Thank you.
So it says in some of these findings of the facts that there was no site walk. Conditional use permit doesn't need a site walk, but they said they must have wanted one, but they didn't do it. Did they ever do one?
It says specifically that they did not.
I think with a building and in a business like this, there should be something done, not just, given that's why I was still old, that I think there was things missed in the application and our ordinances, and that's where that was standing.
Yeah, that's what I was asking about the engineer drawings, because if there's engineer drawings, like no site walk, okay, that makes a little bit of sense, but.
And is it our duty as a zoning board to go into planning board decisions? I think we're just supposed to say whether we think that it was found that they were, that they were in the right or in the wrong, so to speak, I guess, right? Or, and not saying that anybody did anything that maliciously in that way, but I just feel that with something this big and this much controversy, things were messed.
If they weren't, then we wouldn't be here.
Yeah, I think it's part of it is us deciding that the planning board executed their duty successfully, and I think part of that is the site walk. Yeah.
So, to be clear for the board, yes, you're able and empowered to review the planning board's decision making in this process. The specific authority of the board is to reverse situations in which you're capable of reversing the planning board's decision is if the planning board has acted contrary to the town's ordinances, essentially. So if the findings or conclusions are actually in violation of or contrary to the town's ordinances, for lack of a better word. In terms of a determination as to whether the board has sufficient evidence in front of it upon which to rely, the board does have the authority to send the matter back to the planning board for further findings of fact. Specifically, if the board thinks that there's not enough evidence in the record or information provided by the planning board for this board to determine the basis for its decision. but generally the standard that's applicable when it comes to questions of, the sufficiency of the evidence and the ability of the board to rely on it is whether, a reasonable person would consider the information in front of them sufficient to reach their conclusion. So, it's not necessarily whether the planning board is presented with all of the information that this board thinks should have been presented to it, but whether the planning board was presented with enough information that a reasonable, rational person would say, okay, that's enough. And in connection with that, the planning board does have discretion to weigh the evidence that's presented to it. So just the fact that it receives evidence from the applicant saying, yes, the standard is met, and then evidence from the opponent or the butter saying, no, the standard isn't met, doesn't mean that it can't reach a determination that the standard has been met. The board just has the responsibility for deciding who it's going to rely on, or whether it has enough information on the standard of the objection to make its final decision. Long-winded answer to your question.
So the other thing I found was when re-watching the planning board meeting, when the public brought up their concerns, they started talking about some of the issues that were raised around water. Some of the statements that were made by the planning board were that the state would go verify that, or Norm still has to go out there, so he'll take care of that. In specific to the water concerns that were raised by the public, to me, that starts to think that they thought it was somebody else's job to ensure that, which when coupled with no sidewalk and no engineering drawings, I feel like that duty was not executed correctly. And that's part of what has me thinking of, if they thought it was somebody else's job, then they clearly didn't follow Section 3C.
So, just to clarify, it seems like the concern isn't necessarily that they didn't follow it, but whether they had received enough information to actually reach a conclusion that it had been met because they were deferring to other people that had received information from them.
I think that's fair to say. I think potentially, and I'm not speaking for them, but it's not clear to me, and when I couple that with their fact of finding, when they don't have any conditions, even though in giving the transcripts, they said that they could add conditions, and there's no reference at all to how they met the standards, it's very generic. Which, with Christian Fellowship versus Renewal Center versus the Town of Wilmington in 2001, the genericness of that case says that that's not an acceptable answer from the planning board, but it must be detailed. Anyone have any other thoughts or comments?
So, jumping again, it seems like it's the sense of the board that potentially the planning board's findings aren't sufficient or weren't sufficient for them to necessarily reach the determinations and conclusions that they reached, or for this board to appropriately determine whether the planning board acted according to the town ordinances.
Yeah.
So is that just with respect to so far the only issue that's been raised is the surface water runoff and stormwater drainage issues, the buffer strip as well, both of which I think would relate to that section C of the ordinance, related to undue adverse impacts. Are there any other issues raised within the application or within the appeal that the board feels it lacks sufficient findings or sufficient facts to review?
You guys want to take a minute to double check and read through?
heard of it.
I think the, to the extent the board can articulate or identify what it thinks, what else it thinks the board needs to do in terms of fact finding and the statement of the facts that it's relying on, that would be helpful, because if the board is to determine that the planning board's record or the planning board's findings are insufficient, essentially what the board would be doing would be remanding the matter to the planning board for the development of appropriate findings of fact to support their determination.
So I think a couple of things that we would look for would be to conduct a full site walk, require an independent engineering assessment of site drainage and stormwater impacts on public properties, determine which state of being permits or authorizations, including any main right-of-way or drainage authorizations, and any applicable main DEP permits are required for school use, confirm their status, and then make specific written findings on each standard under Article 4, Section 3 and 5, if it reapproves the application, and do so with written conditions addressing the matter identified in the record.
So, frankly, I would have some concerns about this board specifically directing the planning board to go out and look at certain documents or pieces of information. I think it would be more appropriate for the board to say, we don't believe that the record is sufficient to address X, Y, and Z issues, and request that the board engage in additional fact finding and provide its own findings as to these issues, and leave it to the planning board to determine what evidence is or isn't relevant, rather than this board dictating to them what evidence to look at.
Okay, I think we would just want to amend that they would have to put in writing each way that they find approval for Section 3C, if they do reapprove.
So sorry, could you say again specifically what you would like additional findings of that? Respecting, is it all of the approval criteria? Is it specific? Just the item C? Or is it as to it is?
I was thinking Section 3,
So all
C, but the board feel that we should address all sections?
Bad idea, they've done it once, they can do it again.
You know, I would just say that if the concern for the board is the conclusory statement of facts, then that really applies to all three sections. So, to the extent the board's going to remand for one for additional findings, I think would be appropriate, or potentially help avoid any need for future remand to request.
And would it be fair to say that we weren't imposing conditions, but it's matters that the planning board must achieve for fact finding?
I don't think this board can dictate the imposition of conditions, but I think you can certainly suggest on remand to consider whether there are any appropriate conditions of approval that can be attached.
Anything else before we close out deliberation and make a motion?
Nothing to my end.
I have a question.
if this gets voted, it gets put back to the planning board so they can take a peek at it. You know, he's got a lot of time, so does the public, everybody's got a lot of time in this. That's why I think it's really important to put this back and have another eye on it, so everybody has a fair, like, the ordinances looked at again, all the permitting, the application, all of it, just so it's all, because there's so much going on with all of this, and time and money spent. So if we put this back to the planning board, is that gonna, what's that gonna do to, is it 0447? Is that gonna just, we're not terminating anything, but we need to have another look. That's just how I feel. I think it really should have another look.
Yeah, you want to talk about the difference between remand and reversal of decision?
Sure, so if the board were to determine that the planning board erred in or acted contrary to tax ordinances, and essentially should be given to vote to, vacate the planning board approval. And that would essentially be a determination that the permit is, null and void. Again, the board here is acting in an appellate capacity, so the extent to which that decision would be effective is subject to subsequent appeal to the Superior Court, which might disagree with this board and wouldn't have to defer to this board's opinion, but for the duration of the appeal, essentially the permit would be considered done, could be reinstated by the Superior Court after appeal.
Can you define done?
The permit would be
Revoked.
yeah, essentially, would be voided or revoked. With respect to remand, since you're just sending it back to the planning board for additional findings and potential revision, it's not necessarily dead and their approval is vacated, but again, 4047 would be undertaking any continuing activity basically as under risk that the planning board reverses the prior decision of this board upon further review of the additional findings, determines that the approval is invalid.
I just say that if it went back to the planning board for just another overview, I think it's fair to both parties, to the town and to the applicant, 0447. I think that's just the fairest thing to do in my eyes.
Any other comments from anyone? I move that the Parsonsfield Zoning Board of Appeals remand the matter of Smith v. Parsonsfield Zoning Board, 04047, at the adult use cannabis store, back to the planning board. I think we remand with the direction, or not the need for them to respond in written findings for each of the sections that they find approval for. Do I hear a second?
I second that.
Vote. All in favor? All right, what's our next step?
I'll prepare a written decision to the board to execute, and then I think it might be appropriate for the board members to vote to authorize the chair to sign on behalf of the board, providing the written decision comports with, what has transpired here today and the board's actions. And that way, this board won't have to reconvene just to review and sign the written decision.
Does that make sense what you're saying? So in this instance, because I'm interim chair, I would sign the statement. Do I have a motion?
Make a motion that go ahead and sign it.
Do we vote?
Yeah.
All in favor?
Okay, so I will prepare the written decision, submit it to you for your review, and provided it, mirrors what's happened here tonight and the board's decision. You can execute that on behalf of the board, and then at that point it'll be delivered to the year 44/7, and then it will also be provided to the planning board so that they understand that the matter is coming back to them for the purposes of issuing revised findings of fact to appropriately reflect the bases for their decision.
I think there's more business in front of us. How do we wrap this up and then move on?
I think we have voted on it, so that is concluded, and I can move on.
All right, so that matter is concluded, and I believe we have another appeal in front of us. Just a second while we get our bearings, everybody. Anybody have the agenda in front of them? Yeah, okay. Great. So. So I think next we have is the medical and tier 2 cannabis cultivation facility. So the Board of Appeals will review for completeness of the administrative appeal submitted by Stanley Clark, Adam Smith, Sharon Smith, regarding the proposed medical tier 2 cannabis. Sorry. Okay. Okay. All right, great. We'll take a look at that real quick before I pass. Thank you. Okay, yeah, I should have that. This is.
That's for the store.
Subdivision. Okay, yeah, I don't actually have the application, this is somebody have the application. Okay. This is, all of this is, okay, perfect, all right. Woo. So it looks like on the applications, Adam Smith, James Smith, and Stanley Clark. Okay, just wanted to make correct that right there. And do you have, Andy, the requirements to find a appeal complete for review?
I will in just a moment.
Folks, someone's trying to see this, so please take the conversations outside.
So the requirements for a complete appeal are set forth in wherever it is, Article 6, Section 3B of the town code, the town's land use ordinance. And essentially what you need are a written application and a concise written statement indicating the requested relief, and a sketch drawn to scale showing the lot lines, location of existing buildings and structures, and other physical features. Board has in front of it the written application, as well as, I believe, the written statement dated June 4th from the applicants. And then I believe the complete application and the notice of decision. What is the notice of decision of the plan of the property or attached?
Okay, so, are you guys ready to walk through this a little bit? Yeah. Okay. The pages are not printed, but, there is, something that has a couple different Roman numeral sections, and basically it's the grounds for appeal. I want to make sure everyone's got that page. That's, 3 page 4. This page, yeah, looks like. Alright, and it looks like the appellants contend that the planning board failed to make required ordinance findings based on substantial evidence in the record, and properly deferred essential compliance determinations until after approval. Approved the application without resolving threshold legal issues concerning structural legality, access, compatibility, ordinance, and comprehensive plan. It's not our job to determine whether these things are true or not. It's just to verify that they met the requirements for appeal. So I think this meets their declaration of what the appeal is. Would you agree, Kim?
Ultimately, it's a factual determination for the board, but it certainly appears to be a statutory statement of the basis for the appeal.
Yep, thank you. And then the other thing would be a map of the site. Usually people attach the one that they do to the planning board. So I'm guessing this might be back for this time. Does that meet that requirement? If I'm going to that, let me know. Yep, okay, okay. Great. And then, I'm sorry, Cam, was there a third requirement?
Nope. Well, the completed application, but obviously, but the form itself, that was.
Anybody got any questions? Do I hear a motion that this is complete?
Motion is complete. Second it.
Vote? All in favor? Unanimous? Now that we've had this appeal complete, we have to, this starts the clock, 35 days?
35 days to hold a public hearing on the application.
Okay.
Appeal.
And they left. Shoot. I have that right now. All right, so we will post that date publicly as the ordinance is required. Move forward.
If you want to talk today about your own schedules, you
Oh,
can
that's
also
true.
do that.
Yeah, so the ZBA, we can't actually talk to each other outside, so we can't swap emails, we can't, like, it all has to be here in public, so that's it.
For the 3 weeks that's required, the suggested date,
So we have to be at least 3 weeks out because of posting, it has to be posted twice within the, well, it's got to be posted. So we're looking at, phones out. Oh, nice, I'm jealous of them.
So it needs to say that the 12th is the earliest.
12th, you say?
So that'll be August 12th, which is a Wednesday. Well, that's, absolutely. But it's public comment time, man, come on, we know this. We can choose, as long as everyone has to agree. So does 12th, 6 work for you?
I personally will be not in the state the 12th, so I would have to go to attend, but that should not go to boards.
Is there a date that you could?
I don't think that.
And 4 weeks would still be within, I think,
How would it be available on the 19th? Hold on.
6 o'clock? Oh, you won't be, okay. Oh. Just gotta get me up.
Yeah, I mean, it doesn't have to be the Wednesday, so it could be Monday, Tuesday, Wednesday, Thursday.
Yeah, do we want to shoot for the 17th to give us buffer in case things happen?
You're not available on the 17th.
What about the 18th?
Yeah, I'm gone that whole week, so
Didn't you just say the 19th you could think of?
or sorry, I'll just well this week on that. The 17th I can't do, the 18th I need to check my
18th?
The 18th I can do.
Okay. 18th Tuesday?
Yep.
6 o'clock? All right, that's not official until we get the other party to agree, but that's right.
It's within 35 days, so the other party doesn't have to consent to the date of the request of continuance. And if it's outside the 35 days, that is when the party's consent is required.
Is there any official wording I have to use right now for the 16th, or do we have to make a motion? Or the 18th, sorry, the 18th.
Yeah.
6 o'clock?
We can do it on a Saturday if you really want to, or Sunday, I mean. You can just move to that date, but
All right, move to call a public hearing on the 18th at 6 p.m. in regards to this appeal.
Second.
All in favor? Done. All right, this concludes our meeting, folks. Thank you.
A motion to adjourn.
motion to adjourn.
Oh, sorry. Motion to adjourn?
Seconded.
All in favor? Unanimous. Thank you. Just like we can't talk to each other, we can't talk to you guys about specific deals, we can talk about procedure or process.